Companies Act Section 19. Subsidiary company not to hold shares in its holding company. 1. Prohibition on holding shares. Section 19 of the Companies Act establishes a clear and firm prohibition regarding the relationship between a subsidiary company and its holding company. This section specifically states that a subsidiary company is not allowed to hold any shares in its holding company, whether directly or through nominees acting on behalf of the subsidiary. This restriction aims to prevent any potential conflicts of interest and maintain the integrity of the corporate structure. Direct and indirect holding. In practical terms, this means that if a company is classified as a subsidiary of another company, it cannot own shares of the holding company in any manner. Additionally, a holding company is similarly restricted from allotting or transferring its shares to any of its subsidiary companies. Any such actions, be it the holding of shares by the subsidiary or the allotment of shares by the holding company, are considered void. This provision is designed to uphold the principle that a subsidiary should operate independently of its holding company, thereby safeguarding the interests of shareholders and stakeholders involved in both entities. Exceptions to the prohibition. While the prohibition on shareholding between a subsidiary and its holding company is strict, there are specific exceptions to this rule that allow for certain scenarios where a subsidiary company may hold shares in its holding company. 1. Legal representation. The first exception pertains to cases where the subsidiary company holds shares in the holding company as a legal representative of a deceased member. In this situation, the shareholding is permitted because it is not a reflection of ownership by the subsidiary but rather a fulfillment of legal obligations concerning the estate of the deceased. 2. Trustee holding. The second exception applies when the subsidiary company holds shares in the holding company in the capacity of a trustee. In such instances, the subsidiary acts on behalf of beneficiaries, and this arrangement does not violate the prohibitions set forth in this section. 3. Pre-existing shareholding. Another significant exception allows for shareholding that predates the establishment of the subsidiary relationship. If a company held shares in the holding company before it became a subsidiary, this shareholding remains valid and is not subject to the prohibitions outlined in this section. This exception acknowledges the historical context of share ownership and prevents retroactive disqualification of legitimate holdings. Voting rights. It is important to note that a subsidiary company which holds shares in the holding company, whether as a legal representative or a trustee, has specific rights when it comes to voting. In these exceptional circumstances, the subsidiary is entitled to vote at the holding company's meetings, but only concerning the shares held in those capacities. This provision allows for representation at meetings while still adhering to the overarching principle of preventing a subsidiary from holding shares in its holding company as a matter of course. 2. Interpretation for non-share capital companies. The section also provides specific guidance on the interpretation of the term shares in the context of companies that do not operate with traditional share capital structures. This is particularly relevant for holding companies that are limited by guarantee or are classified as unlimited companies without share capital. In such cases, the term shares, as referenced in Section 19, should be understood to pertain to the interests of its members, regardless of the form those interests take. Application of the non-holding principle. This interpretation ensures that the principle prohibiting subsidiaries from holding shares is applied uniformly, even in companies without share capital. It recognizes that member interests in such companies may be structured differently but still carries the same fundamental implications regarding the relationship between subsidiaries and their holding companies. By extending the prohibition to encompass all forms of member interests, the Act maintains the integrity of corporate governance and ensures that the rules surrounding ownership and control are consistent across different types of corporate entities.